Perfect. So good afternoon and welcome everyone to the third and final in Legal Aid Alberta's webinar series in celebration of our 50th anniversary. My name is Wyatt Fraser and I'm Legal Aid Alberta's engagement facilitator, and I'll just be helping to hopefully make sure all the tech runs smoothly today. So thank you again for joining us for today's webinar, Family Violence and Emergency Protection Orders. November's Family Violence Prevention Month in Alberta, and today's webinar will provide key information about family violence, emergency protection orders, and the role Legal Aid Alberta helps play in keeping Albertans safe. In a democracy, the principles of justice and the protection of legal rights are the cornerstone upon which society is built. These principles remind us that every individual deserves equal protection under the law, regardless of their circumstances. At Legal Aid Alberta, this belief is not just a sentiment, it's the very purpose that drives us. Helping to ensure an effective, efficient, and balanced justice system since 1973, our dedicated team of lawyers, frontline workers, and administrative professionals strive to not only protect the rights of disadvantaged Albertans, but ensure their individual voices are heard as well. Through our work, we provide solutions to promote and enhance not only our clients' well-being, but that of our communities as well. Legal Aid Alberta represents approximately 35,000 Albertans at any given time, spanning 75 communities across the province. Our Justice of the Peace Bail program conducts approximately 30,000 bail hearings annually, and duty counsel lawyers serve countless thousands of Albertans every year by providing free legal advice to those appearing in court for their first time. Public education is a key priority for us, and this webinar is being recorded and will be made available on demand on our website next week. All attendees will receive an email with a link to the recording once it's available. By default, your microphones and cameras are disabled, but you can engage with us using the Q&A feature in Teams. And as a reminder, this session is not intended as a forum to obtain legal advice about a specific situation, but rather aims to educate about general legal processes and Legal Aid Alberta services. To ask a question, you can click the Q&A button at the top of your Teams window. So if you look along the top, there'll be a little button that says Q&A. Once you click that, a dialog box will open to the side. You're able to enter your question and hit post. We do expect a lot of attendees today, so we'll try to get through as many questions as we can at the end of the presentation. We'll also be sharing a link at the end of today's session for attendees to complete a quick anonymous survey, as we love to hear your feedback about today's session, as well as getting suggestions you might have for other topics that you're interested in learning about. In the spirit of reconciliation with Indigenous, First Nations, Métis, and Inuit peoples in Canada, Legal Aid Alberta makes a solemn pledge to work towards positive change in the legal system for fair representation with consideration of these communities' unique and historical situations. We respectfully acknowledge that we are situated on the ancestral and traditional territory and travel routes of many peoples, including those on the land of Treaties 4, 6, 7, 8, and 10. The Blackfoot Confederacy, Kainai, Piikani, Siksika, Dene, Saulteaux, Nakota Sioux, Stoney Nakoda, Cree, Tsuut'ina Nation, and the Métis people of Alberta. We recognize the challenges faced by our Indigenous, First Nations, Métis, and Inuit clients involved in the justice system. We commit to meaningfully respond to the Truth and Reconciliation call to action and the missing and murdered Indigenous women and girls call for justice. To do this, we strive for action and accountability through our Indigenous Action Plan. This plan aims to continuously engage with these communities to better develop relationships, opportunities, programs, and practices to serve our clients. At Legal Aid Alberta, we're committed to providing education for management and staff on the history of Indigenous peoples. We are looking to establish panels of lawyers trained on the history of Indigenous, First Nations, Métis, and Inuit clients and communities with consideration of their history under the laws of Canada. We are participants and dedicated members of the Indigenous courts in Alberta. In an act of reconciliation and gratitude, we acknowledge all Indigenous, First Nations, Métis, and Inuit peoples who have lived in and cared for these lands for generations. We express our continued thanks to be able to work on these lands and represent Albertans in this territory. And now it's my pleasure to introduce our presenters for today. So we have Legal Aid Alberta staff lawyers Jessica Chapman and Julia McGraw. We also have staff lawyer Jackson Lee on hand, who will be able to assist during the question and answer period. And with that, I'll turn it over to Jessica to get us started.
Thank you, Wyatt, and thank you everyone for coming. So here's our agenda for today. First, we're going to talk about family violence and how big the problem is. We're going to talk about emergency protection orders and what they are. We're going to give you some legal definitions made simple, and we're going to talk to you about how to apply for an emergency protection order. So EPO stands for Emergency Protection Order. You're going to see that acronym a lot today. So Family violence is actually a huge problem, and keeping in mind that there's different types of family violence. So I'm not just talking about about violence between intimate partners. We're talking about any type of family violence, including elder abuse, child abuse, and other types of family violence. Um, in Canada in 2019, almost or actually more than a quarter of the reported violent crimes in Canada were the result of family violence. And in 2019, Alberta had the third highest number of police reported family violence victims. Now, that doesn't uh, totally reflect the problem because we know that most people who are experiencing family violence don't report to police for a variety of reasons. And a 2019 study said that only 1 in 5 victims will report to police. Um, During the pandemic, we know that family violence increased, and we've seen steady increases year over year. But it was doing that before the pandemic as well. 2021 was the seventh consecutive year with a gradual increase in police reported intimate partner violence. And that's just a fraction of what is happening. So I'm just trying to think here. Emergency protection order files. So these are the numbers of the files that were opened at Legal Aid Alberta, and this is for across the province. Now, we don't have duty counsel lawyers at every courthouse in Alberta, but we have them at several, and these are the files that we've opened. You can see that since 2017, they increased. There's been a small drop in 2022, 2023, but not a significant drop. Now I think I'm turning it over to Julia.
Yeah. So to just chat about emergency protection orders. So basically, what do they do? So an EPO can stop a person, we call them the respondent, from going near a place or entering a specific location. So, for example, it could state that someone cannot be within 200 meters of your home. It can prevent a person from communicating with the claimant, so the victim, and other persons. So that could include children or other family members, and that's directly or indirectly. So that includes having someone reach out on someone's behalf. An EPO can allow a claimant to live in a residence, so that's whether or not they rent or own the home, and prohibit the respondent from being at the resident. It can assist a peace officer to accompany. It can either be the respondent to retrieve belongings, or it could be the claimant if they have left the residence. For example, if they're living in a shelter, we can have the police assist them getting their belongings, often for themselves or children. We can ask that in an EPO, weapons be stored and seized. So typically firearms, but it can be other weapons. And the court can also direct any other term that they find appropriate if the legislation allows. And so, in order to obtain an emergency protection order, a test has to be met. So, based on the Act, parties must be family members. So, that can include former family members, so married, divorced, uh, people living in an intimate relationship, parents, brothers and sisters, parents and children. The court has to find that family violence has occurred. And family violence is very specifically defined in the Act for an EPO, so that it doesn't necessarily encompass all violence, but it's specifically defined. The court has to find that they believe that the family violence will continue or resume. And lastly, they need to find that there's a seriousness or urgency to grant the immediate protection of the claimant. So an EPO, the key is that it's a very urgent situation.
So I'm going to talk a little bit more about the definitions. So The Protection Against Family Violence Act does set out these definitions, and we haven't repeated the entire definition here. But as Julia was saying, it's if you have been married or are still married to one another, if you are residing or resided together in an intimate relationship. And it's important to note that there's no specific timeline set in the legislation for how long you have to live together to be considered residing or resided together. If you have children with the person, then you are family members. If you are related by blood, marriage, or adoption, you are family members. And any children in the care of any of the people listed above are also included. Uh, Persons who live together and one has care and control over the other pursuant to a court order like guardianship or trusteeship, such where there's dependent adults, those people are also family members. What is not included is dating relationships. So if you are dating someone but you've never lived together, you would not qualify for an emergency protection order. You'd have to look at other types of restraining orders. Family violence is defined in the Act as any intentional or reckless act that causes injury or harms a family member or that damages property, any act or threat to act that intimidates a family member by creating reasonable fear of injury or property damage, forced confinement, sexual abuse, and stalking. What is not included here, and you may have heard this in other discussions about family violence, is coercive control, although arguably there's a lot of parts of coercive control that would fall under the act or threat to act that intimidates a family member. So while coercive control is not specifically listed in the definition, it is a consideration for sure. In terms of defining emergency, emergency is not a defined term in the Act. The Act says that the person making the decision must find that the situation is serious or urgent and that the order is necessary for the immediate protection of the claimant and other family members. So there doesn't necessarily have to be an emergency at the time the EPO is applied for, but it does need to be serious and you do have to need the order immediately.
Okay, so now we're just going to run through the process of how an EPO can be obtained. So we'll just talk about the application, the hearing, how it's served on the respondent, and then the next step. So in order to apply for an EPO, you can either phone the phone numbers listed. There's the Calgary number listed. There's the Edmonton number listed. Anywhere else in Alberta, certainly you can contact the police. And of course, if there's any immediate danger, call 911. So typically, we'll say, for example, if you head into the Calgary courthouse, so we can just go to the next the next slide, please. Okay, so the hearing. So if it's in Calgary or Edmonton, it would either be before an Alberta Court of Justice, or the Justice of the Peace. So there'll be a hearing where the claimant or police on their behalf will make an application to the court explaining what's been going on elsewhere in Alberta, so you can always attend at your local courthouse. There's also the after hours telephone applications by the Justice of the Peace. Those are run every single day of the year, including any holidays and also overnight. So at the hearing, the Justice of the Peace or Alberta Court of Justice will either grant the application or deny the application. At the hearing, everything that is said is put into a transcript. And if the order is granted, the court will prepare the copy of the order and it will be sent to a local police, so police or RCMP. At that stage, if we can just move to the next slide. then the EPO will be served on the respondent by a peace officer. So the claimant is not responsible for getting the order to the respondent. The police will do that on the claimant's behalf. If they can't locate the respondent, then they will apply to the court to have an order to serve them either by email, text message, or social media. So the police are responsible for that portion. And then the EPO would be in place immediately once it's been granted. So then after 9 business days after the EPO was granted, it has to be reviewed by the Court of King's Bench. So that's required in the legislation. So at the EPO review, it can either be confirmed, so it can be put in place for up to 1 year or any time between that. It can be revoked, so that would be removed immediately. So both the claimant and the respondent attend court at this stage. So currently, we can attend either in person or virtually, so by WebEx or telephone. And again, at this stage, the court can either confirm or revoke. If the court needs to hear further evidence, if there's conflicting evidence between the parties, the court can set the matter for an oral hearing, and that's typically a few months down the road, but the order would stay in place until that time.
So at Legal Aid Alberta, we have a program that is available free to the public, and we call it our Emergency Protection Order Program. And in Edmonton and Calgary and some of the other larger centers, we have staff lawyers doing this work. But there's also a great deal of roster lawyers. Legal Aid has a wide variety of lawyers who offer their time to Legal Aid, who provide duty counsel services for respondents and sometimes claimants if one of our staff offices has a conflict. So the first part of what our team provides is we have lawyers that actually help claimants doing the application, the initial application in the Alberta Court of Justice, which used to be called the Provincial Court of Alberta. So it's the same place, and I might use the words interchangeably, but for instance, at the Edmonton Courthouse, there's a lawyer on site that you would be directed to if you were applying for an EPO, and that lawyer would help you prepare the application and also help you give your evidence in court. And that is also available in Calgary. I think those are the only 2 places in the province that particular service is available, but certainly we help a large number of claimants there. We also provide duty counsel to all claimants and all respondents in Court of King's Bench. And that's to ensure that the process is fair to everyone involved, that everyone gets a chance to talk to a lawyer and have assistance. And so with claimants, the files are automatically assigned to staff lawyers. With respondents, they're given an information sheet when they're served with the emergency protection order, and it shows them how they can follow the process and how they can obtain their own duty counsel lawyer from Legal Aid Alberta. Sometimes it's confusing to people because for most Legal Aid Alberta services, you need to apply for coverage, but for emergency protection orders, this is duty counsel and it's free to all Albertans. You don't have to meet any financial eligibility guidelines to get help. And that's for the review stage at Court of King's Bench. Now, if at the review stage the matter gets set for an oral hearing, that is when coverage is not automatic. That's not duty counsel anymore. There still are lawyers that run those hearings who are assigned by Legal Aid, but the claimant or respondent has to call into Legal Aid, apply for coverage, and meet those financial eligibility guidelines. Our emergency protection order team also does a lot of education. So we do many presentations, we do training sessions. We just had some lawyers in Edmonton who assisted with a training presentation for police. We do presentation to victim services units and many other community organizations, and we do things like we're doing today. So we had some tips for successful applications and what you can expect. So going to court in general can be very stressful. And when you're making an application up and you have to talk about the family violence that you've been experiencing, obviously past trauma can be triggered. I think, we talked about what a big problem family violence is at the beginning of this presentation. And what is always so amazing to me is that I meet so many claimants, at least, 10 to 15 a week because I do every Wednesday. And all of them are usually feeling very alone. And this is a very common problem in society. And still, people feel completely alone when they're dealing with it. And if there's one message I'd like people to take away from today is that you aren't alone. And there is help if you are trying to deal with family violence. It's really common to feel overwhelmed, embarrassed, or sad. You can bring supports with you. If you have a support person, it's fine to bring someone with you to make an application. They can be in the room while you testify as long as they're not testifying. It's also important to seek an emergency protection order sooner rather than later. Sometimes if there's a period of delay between the incident that is leading you to apply for the emergency protection order and the date that you apply, sometimes judges will have concerns about why you didn't apply sooner. Sometimes, though, there's really reasonable explanations. So often people are dealing with huge changes in their living situations, or maybe they just didn't know where to go and they just found out that an EPO is available. So just because there's a delay doesn't mean I'm telling you not to apply, but it is better to do it as soon as you know that that remedy is available to you. So common questions that you could be asked when you're making an application, you're going to need to explain how you're related to the respondent because the judge needs to make sure that you're family members. You might be asked to, well, you will be asked to give examples of family violence that has happened in the past, as well as the most current family violence. You have to be able to explain why this order is necessary right now. It can be really hard to remember exact dates, and you need to be a little bit forgiving of yourself if you don't know them off the top of your head. Most people know things approximately, so this month or a week ago. If you don't know the exact dates, that's not something to don't let that prevent you from making an application. The better you know the dates, the easier it is for other people to follow the story, but it's just not always possible. So here's some more questions that you would be asked when you're making an application. The judge is trying to make sure that the EPO is necessary for your protection. So they want to know, what is the risk if the emergency protection order is not granted? What do you think is likely to happen? They'll ask you if you reported to the police and if there's any charges laid. You don't have to report to police to apply for an EPO. It's not a necessary precondition. You might have very valid reasons for not wanting to go to police, and this option is still available for you whether or not you report to police. You will be asked whether or not you've applied for any previous EPOs, and that's so that the judge can understand the history. Many people apply for EPOs with the same respondent more than once. Cycles of violence can be really hard to break. And so again, you'll be asked about it, but it's not going to be a reason that prevents you from getting an EPO. You'll be asked about other factors, like does the respondent have issues with mental health or addictions? Does the respondent have access to weapons? Some of these questions may not be relevant to your situation, but the judges will still need to ask you. They'll also ask you if the respondent has a criminal record. If these are all things that you shouldn't guess about. If you don't know whether or not they have a criminal record, you can just say you don't know. Often people have records that, their family members don't know anything about. So
Okay,
I think
so
it's
just,
over to Julia.
yep, it is. So just some safety tips. So make sure that you're checking in on people regularly. If someone is telling you that they're experiencing family violence, believe what they're saying. Uh, just stay informed, do your homework. Provide referrals to community supports if it's necessary, and also try to have a safety plan in place. One of the services that Legal Aid provides for claimants is to help them have safety plans. So we have justice navigators who will work with claimants and make sure that they do have a safety plan in place and send it to them so that they know other community resources that they can reach out to and where to call for help if they need to. So then just the next slide, please. Okay, and so where are some other areas to find support? So certainly if you need an EPO, contact Legal Aid. Go down to the courthouse and we can assist you with either your EPO application or your review. There's also legal clinics throughout most cities, even smaller centers. There's also social support agencies. So we've talked about already victim services. So if you're also dealing with a criminal matter related to the respondent, victim services is available to help. There's the Edmonton Violence Prevention Center, the City of Edmonton Violence Prevention Team. There's also a variety of local shelters. So that can be certainly for female or male claimants. There's also shelters for youth that can assist family members dealing with violence. And of course, police services.
Perfect. Thanks, guys. That kind of brings us to the end of the PowerPoint slides that we have prepared. But again, we want to leave plenty of time for questions. I know some are coming in. So I did have instructions on the screen on how you're able to ask questions here. But again, just as a reminder, if you look at the top of your Teams window, or if you're on your phone, you can click the dot, 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 and then from there you can select the Q&A feature. You'll get a little dialog box that pops up to the right on computers, to the top on phones. And from there, you're able to say, under start a discussion, you can write your question, hit post, and then it'll just take a few moments to go through, and then we'll be able to ask to our presenters. So I know we had touched upon it a little bit, but one of the questions we received is what are the kind of options available for people that are not family members? So if whether they're dating and might have keystone on others' places, or they're just not in a relationship of that kind, what other options are available for Albertans?
Sure, so I can respond to this one. So, for non family members, you can always apply for a restraining order. So, you're able to attend at your courthouse, and typically resolution services or the clerks will provide you with the paperwork to fill out your application. Those applications can also be done without notice to someone else. So, for example, in a dating relationship, you still can get an order same day if it's necessary. There's always King's bench protection orders. So for family members, if it's not an urgent situation, you can still apply for an order, just again, not on an ex parte basis. So in that situation, the respondent would know you're making the application. So the urgency factor isn't necessary.
Thanks, Julia. I just want to check, Jessica, do you have anything to add just before going to the next question?
Nope.
No? Awesome. We just had someone looking for a little bit of feedback on just why isn't coercive control considered family violence in the Act? And then maybe as well, if you guys were able to explain just a little bit what coercive control might be, in case it's a new term for some folks.
So coercive control is a pattern of behavior where um, there's a lot of types of controlling behaviors. And so one of the most common examples is, insisting on going through someone's phone or, preventing them from having access to a phone or there's all kinds of things that fall under that I can't really give you an exhaustive definition. And it's not that it's not considered violence in the act because if you look at like I've judges will look at patterns of behavior and see if they meet the definition of family violence in the act. It's just that it's not specifically enumerated as part of family violence in the Protection Against Family Violence Act, and I think it has to do with at the time the act was written, coercive control was not commonly talked about. There's been a lot of academic scholarship done on it now, and it's also now one of the definitions included or it forms part of the definition of family violence included under the Divorce Act. Um, so that's why people tend to notice it missing from this particular definition, but those patterns of behavior can still be considered.
Okay, thanks. I believe we touched upon it a little bit, but we're just looking for confirmation. So they're just asking, is there any financial eligibility criteria for EPO duty counsel for claimants or respondents? So again, specifically, I think for the first review here.
Sure. So for the first initial reviews, there's no financial eligibility. Every Albertan will qualify. There's also no repayment criteria. So you will be provided with duty counsel. Again, you don't have to provide any of your financial information because it's not required. So everyone does qualify.
Yeah, thanks. We had a question that I can answer. Someone just had asked if the slides will be available afterwards, and I can confirm they will be. So in the follow-up email that we'll send, again, probably early next week, with a copy of or a link to the recording, we'll also have a copy of the PowerPoint slides that'll be available as well for anyone. Okay, so I'm just going through questions here. Are there any limitations to file an EPO? Can people file ex parte?
An EPO by definition is ex parte, so that just means that someone is applying at court without the other person, well, typically knowing. So the court is granting the order based on just one person's evidence, and that's why the orders are reviewed in the 9 business days, so that the court then has the benefit of hearing from both people.
Okay, thank you. We had a question. If the respondent's in another province, does that change anything in the process?
It can be a factor in determining whether or not the court will grant the order. Sometimes that does have an impact on whether there's an urgent need for an EPO if the respondent's not in the province, but there's always situations where they're returning to the province, then it's not, it wouldn't prevent someone from applying.
We should mention as well that EPOs can only be enforced inside the province of Alberta. If you can't rely on an EPO to protect you if you're in a different province, and it would only apply while you're in Alberta. So there are generally each province has its own type of protection order legislation. So if you're in a different province, you need to look into that.
Thank you. We just had some the question about just kind of asking if we're able to provide any like links to resources or supports in potentially some of the smaller communities. So I wonder if that's maybe something that in the follow-up email, maybe we could look at, again, just going to not to put us on the spot, but we could potentially look at, having some links as well or some supports and referrals to community resources that might be able to help out.
Yes, and I just wanted to mention as well that one of the good things about the time of COVID is that now you can make an application for an EPO by telephone to the Justice of the Peace hearing office. And so you don't, if you live in a community that's outside a major center, you don't have to travel in. You can actually do it by phone. You do have to be able to produce identification and send copies into the hearing office ahead of time. But the Government of Alberta website has the instructions on how to do that. So that would definitely be a link that we'd want to include, Wyatt.
Great. We had a question after the review, if an EPO is revoked, can the claimant, upon a further incident of family violence, reapply to commence a new or fresh EPO application?
Yeah, absolutely, they can do that. And there's no prohibition on, if you could have 10 EPOs against the same person over a relationship. So it doesn't matter that an EPO has been revoked. Even if it's by consent, you can always reapply if there's any other further violence.
Okay, thank you. We had a question. Do you need to be able to prove that you live together? So, for example, both being on the lease or other proof?
You don't have to have documentary paperwork to prove that you live together. Generally, if you testify to that under oath, that will be sufficient to have the EPO granted. In the later stages, when you get to the review stage, if that's contested and the other party is saying that you never did live together, then it may be useful to have some paperwork, but it doesn't stop you from applying if you don't have the paperwork.
Okay, thanks. We had a question, does electronic stalking count as a form of stalking under the family violence definition in the Act?
Yes.
Okay, perfect, thank you. So I think we have just a follow-up question. So someone was just confirming. So once an EPO is granted, it does not become a federal order that's recognized in other provinces. Are you able to confirm it's just in Alberta?
It's just an EPO is just Alberta based. If a person, if they can get a restraining order, it's by the Court of King's Bench. Sometimes we can have more success with other provinces recognizing those orders because it's not just based under the Protection Against Family Violence legislation, which is only Alberta based. But people are also able to obtain orders in other provinces if they need to as well.
Okay, thanks. So I'm just looking through questions here.
One thing we didn't mention is that the maximum amount of time that an EPO can be in place under the legislation is 1 year. So at the review hearing, that's the longest period of time a judge can leave it in place. Sometimes those can be renewed, but then you have to bring an application in Court of King's Bench to extend the EPO before it expires. So that's sort of the timing on EPOs as well.
Okay. We had a question, is it possible for someone to cancel an EPO after it's been granted? So if the claimant later ends up deciding that they don't want to keep the EPO in place, is it possible, or does it have to stay for the full period it's granted for?
It can be revoked. It can be revoked at the first review if the claimant is asking for that. And most orders have a clause that either party can apply to vary the order on notice to the other person. So it doesn't happen often, but we do see situations where claimants, after maybe a few weeks or a few months, have decided they no longer feel like they need the protection and they can bring an application to the court to have it revoked.
Okay. We had a question about whether Legal Aid Alberta provides coverage for restraining orders for an applicant or respondent, and then just inquiring about the eligibility criteria.
So I know that as a staff lawyer, I have been assigned certificates to apply for restraining orders. And so if you look in the website, there is information about financial eligibility guidelines, and there are instructions on how to apply for coverage. So you would simply phone Legal Aid Alberta and explain why you needed a restraining order, and they would ask you all of their intake questions about financial eligibility and then decide whether or not to assign your file.
Right, and just to further on that, during the application process, it would also be gathered information, like background information about what's going on, similar instance, the same type of information, so that a staff lawyer is able to determine if the restraining order is appropriate, or if it might be maybe an emergency protection order would be more suitable at that point in time. We had a question, if a claimant has a criminal record, would that impact the application they're trying to make for an EPO?
No, it doesn't. That is not like if you have a criminal record and you need an EPO, you should still apply for an EPO. You might be asked about criminal records, but it's not a reason to deny an emergency protection order. Likewise, if there are criminal charges against the respondent and want an EPO, you can still get an EPO. Just because there are release conditions for a respondent does not mean that you should not have an EPO.
And just to add on that, there's often release conditions related to criminal matters. So, for example, the respondent is not able to be near the victim and, for example, the residents, but the order might not include the children, which is something that a claimant might want. So, the claimant can also apply for an EPO to ensure that they are protected as well as their children or other family members that aren't on the criminal order.
Okay. That actually ties into a question we had about whether an Alberta Court of Justice can vary the terms of an EPO to allow for parenting. So if there's an EPO in place and the other party files for a parenting order, what impact might that have on EPOs? Or,
So the adjourning orders that are granted in the Court of King's Bench after the 9-day review have a standard provision that says that any parenting order granted subsequent to the EPO, any contact pursuant to that parenting order will not be a breach of the emergency protection order. So if there is an EPO in effect and the children are included, then you need to get a parenting order to be able to see those children if you're the respondent, and you can do that in the Alberta Court of Justice or in the Court of King's Bench.
Thanks. We had a question. So if your family members, whether that's brother, sister, mother, father, did it at one time live with the claimant many years ago, but does not currently and has not for a while, would an EPO still be applicable? So again, that's between like I guess immediate family members by blood, so brother, sister, mother, father. Are those individuals still able to apply for an EPO against their family member?
Yes, so they would still be considered family members. So once the definition of family member has been met, so example, you know, husband, wife, brother, sister, you don't also need to be living together, and they don't need to be recently living together either to be considered a family member.
Thank you. Let's check. I think we had there was just a similar question. Okay, so yeah, sorry, another question was just getting confirmation. So if it was sibling against sibling or parent against adult child, those would also be applicable for an emergency protection order?
Yes.
Correct.
Okay, thank you. We had a question here, so it's a bit of an involved one, so I'm just going to read out. So if a complainant puts an EPO in place in Alberta and then the respondent moves to a different province, such as Saskatchewan, would the EPO still be in place in Alberta? So if someone's left, does that EPO still remain in effect for the full 12 months?
Yes,
So
the
If
order would still remain in place in Alberta. Enforcement in Saskatchewan, again, as we talked about before, the order it is restricted to Alberta in terms of enforcement, but it would remain in place for until the order does expire. So it doesn't matter if the person has left the province.
and then
so for the claimant, from the claimant's point of view, it's most important for you to get the protection order in the province where you're currently living, because that's where you're going to need the protection.
okay. And then is there any type of court application the respondent can make during the course of the EPO to try to like revoke or to have it canceled?
So they can attend at the review and just ask for that. That's basically what the court is trying to find out at the review process is this something that the respondent is agreeable to, or do they disagree entirely with this order? And so they can ask to have it revoked at a review hearing or set a hearing down the road to ask to have it revoked. After an EPO is confirmed, like Julia was saying earlier, there's generally a provision in every confirmation order that says that either party can apply to vary the order on a certain number of days' notice, usually 5, I think.
Okay, thank you. We had a question. If someone has an EPO or is seeking an EPO in Calgary or Edmonton and it's outside of normal business hours, are they still able to apply for the emergency protection order program, or what would their best action be?
So the JP hearing office, they run from the time that the courthouse closes until the next morning and also on the weekend. So you can obtain an EPO at any time of the day. If it's during business hours, it would be through the Alberta Court of Justice. And if it's after hours, any stat holidays when the courthouse is typically closed, you can go to the hearing office. So you can either go in person at the larger centers or phone the telephone number and have your application heard over the phone.
If you're calling after hours, you would not be able to have assistance from a staff lawyer from the emergency protection order program. But if you apply after hours, still when you get to the review stage, because the reviews are always done within business hours, then you would definitely have duty counsel available to you at the review stage.
Thanks. Uh, we had someone just looking for a bit of follow-up. So what would be the main role of a defense lawyer in an EPO hearing?
Uh, Well, a defense lawyer, it could be they're just acting as counsel or duty counsel for the respondent. So they would just be letting the court know what the respondent's position is.
And putting the evidence forth. So the transcript is the evidence of the claimant. That's the written down record of everything the claimant said at the original hearing. And then the respondent has a chance to put forth their side of the story in sworn evidence that we call an affidavit. So it's written down, the respondent swears it under oath, and that becomes the evidence for the judge at the review to look at.
Okay, we have the question, does the respondent have a criminal record once an EPO expires? So I guess, will the EPO affect someone's criminal record might be another way to phrase that.
If there's no breaches of the order, then no. The order is all EPOs and orders coming out of the review are sent to peace officers, so they are put on the police system. There wouldn't be a criminal record if there's no breaches of the order. If a respondent does breach an EPO, there are certainly consequences for that. The police can arrest. There are fines just depending on the number of breaches to an EPO, so they can be arrested for breaches.
Thank you. Good question. If you apply for an EPO and it's not granted, are you then still able to apply for either a King's Bench protection order on notice to their party or a restraining order? So if the EPO application is unsuccessful, what impact does that have on subsequent types of applications?
I would say it depends on the reasons why it wasn't granted. So if you are denied an EPO because you're not family members, then you would be able to apply for a restraining order. If it's because there's no family violence, that if there's no finding that family violence has occurred, or then it's unlikely that you would be successful in applying for a different type of protection order. If it's for the reason that it lacks urgency and it could be done on notice, then you may still be um, successful in applying for either a restraining order or a King's Bench protection order.
Okay. We had a question just in regards to affidavits. Are there any page limits or like limits for affidavits in support or response to an EPO review? So is there any type of guidelines around how long a response should be? Is there a page limit, that sort of thing?
Yeah, so there is, if the matter is going to an oral hearing, the court typically limits the respondent's affidavit to a certain page number and so many pages of exhibits. And they also allow typically the claimant to provide an affidavit in response to that. Usually that's limited to 5 pages of written material and up to 10 pages of exhibits. But at the review hearing, the court can always vary that if they want to.
Thanks. I think we had a follow-up to the previous question about what can defense counsel do. So they just add the follow-up. So if the respondent is not objecting to the EPO and then during the hearing, that's the question asked by the judge. Or is there anything more that a defense lawyer can do during such representation? And again, that was a follow-up to earlier question just on what's the main role of the defense lawyer. So
Well,
what
they
should they be
may
doing? Mhm.
it may be that the respondent doesn't object to the emergency protection order. Like I'll often hear respondents say that they don't want to have any contact with the other person in any event, but it may be useful to have legal advice to help you make sure the conditions on the EPO are going to allow you to live your life the way you need to. So if you have children together, there may be certain provisions or exceptions that you need the order to say such and such is not a breach of the order. So if you have to call the other parent about a medical emergency, that won't be a breach of the order. Or if you need to communicate about something. So there can be a wide variety of conditions or exceptions that could be negotiated. And it's important to get advice about those things.
Okay, thanks. We had a question. Is there any type of appeal process in the courts if an EPO is denied?
Pract Practically speaking, if an EPO was denied, then a person would most likely apply for either the restraining order or the King's Bench protection order. Appeal processes take quite some time. So if the ultimate objective is to have yourself protected from a person, the better course of action would be just to apply for either the King's Bench protection order or the restraining order. It wouldn't make a ton of sense to just wait um, such a long period of time for an appeal to be heard.
Okay. We had a question that kind of follows up on that. So, under what circumstances would a Court of King's Bench restraining order be the preferred route? Say, just commented less urgent. Do you guys have any other circumstances that where you think the like a restraining order from KB would be more appropriate than a EPO?
If there's no urgent circumstances, or perhaps if someone knows that the respondent would be out of the province maybe for a month or two, they could certainly apply for the King's Bench protection order and have that done prior
There's
to the
all
person coming back.
there's also some additional things that a King's Bench protection order can do. You can be compensated for damages that you've suffered, like out-of-pocket expenses, essentially not personal injury damages. So there are some additional remedies and some additional things that can be ordered. Unfortunately, there is no duty counsel program for King's Bench protection orders.
Okay, thanks. We had a question just about the transcripts. Is there any cost for the applicant to get the transcript from the review hearing?
From the review hearing, there is a
Mhm.
cost. From the initial application before either the JP or the Alberta Court of Justice, those are provided automatically at no charge. But at all the review hearings, it's the same for typical family or civil matters. So you do have to request and pay. It's based on how long the transcript is and how fast you're wanting the transcript back from the court.
Okay, thank you. I think someone's just looking for confirmation. So, as a claimant, can you revoke the order at any time? So, example, after it was confirmed at the review date and oral hearing, after X days, you're still able to apply to vary or revoke the order.
You
Yes.
can you can. It may require filing an application and an affidavit before the court if you're outside of the review hearings and it's been confirmed.
Okay, thanks. Uh, sorry, a little bit longer of a question, so bear with me here. So, what happens if the respondent and complainant were ordered to attend the oral hearing and the respondent missed the filing deadline for their affidavit? So, what can the respondent do at this time? Will the justice give the respondent another opportunity to file the affidavit? So I guess just questions around the filing deadlines for affidavits. What's the impact if someone misses? Can it be filed late? Maybe you'll just provide some comment.
It can be so you might have to go and ask a justice for permission to file it late. Sometimes that's called getting a fiat. If you're at the actual hearing and you haven't filed, you'd have to ask the justice for that. It could result in an adjournment. So if the other side needs a chance to review and provide a response to your affidavit, they might ask for an adjournment on that basis, or you might be asking for an adjournment to have more time to prepare your material. But you should do your very best not to miss the deadlines because the justice could say, no, we're proceeding today.
With the question, can the application for an EPO be made at the Court of King's Bench level as well, or is that just at the Court of Justice and Justice of the Peace?
If it's the initial application, it would just be made before the Justice of the Peace or Alberta Court of Justice. If your first application that you're trying to make would be before the Court of King's Bench, then that would be for a King's Bench protection order. And with that, the respondent does have a notice of your application. So again, sometimes that can be a safety concern. So you might want to go with the EPO route.
Okay, thanks. Question some folks had to see is when you go to court, either for the review or oral hearing, is do you have to see the other party in court? So if someone has a fear of the respondent, are they forced to see them in court when they attend?
If it gets to the oral hearing stage, then you will have to see them. The other court appearances in the Court of King's bench where you're doing the review applications, you can attend virtually through WebEx or telephone. So you wouldn't necessarily have to see the respondent, although you would likely be able to hear them speaking, which I know can also be difficult for people.
Okay, thank you. And then just as a note, I see we have about 5 minutes left. So again, we welcome if more questions, any more questions to keep coming in.
I was just wondering if anyone had questions because we do have our criminal law expert here today. And so if anyone has questions around being charged with breaches of EPOs, Legal Aid Alberta also provides criminal law services, and I'm sure our expert could speak to that.
Yeah, so maybe Jackson, if you're available, I guess what's a typical consequence or what's the process if someone breaches an EPO? So if the respondent does not comply with the conditions set in, what would kind of be the usual process?
Well, I would say that's usually the police would get involved and charge the person. I work as duty counsel on the criminal side, so I'm assisting people at that stage when they're charged and appearing before the court. But generally speaking, they're gonna get a charge for breaching an EPO, and then that does bring it into the criminal realm, and there are potential criminal consequences for that, such as going to jail, having to pay a fine, etc. And as far as what a typical consequence might be, I mean it really depends on the nature of the breach. Like there can be really a scary breach, let's say, where someone's found outside your home late at night or something, following a person, something that really seems like it's potentially putting someone in danger. And jail time would likely be the result of such a breach. And then you get very minor breaches where someone called about something, they phoned to ask about the kids, they shouldn't have, but there wasn't really anyone put in danger or anything too aggressive. And especially if a person has no criminal record, they're going to be looking at something on the minor end of the scale, like a fine or something like that. So I guess when the breach happens, it brings the sort of the criminal consequences into play, and then what happens from there really depends on the circumstances of the nature of the breach and any past record that the person might have, the one who's accused of the breach.
Okay, perfect. Thanks, Jackson. We had a question, what are the benefits of doing a mutual no contact order in comparison to confirming the EPO? And then is there a difference between those types of orders? This might be more on the Jessica and Julia side, maybe. You're on mute, sorry, Jessica.
You're muted.
I can answer. So it can be a bit of a balancing act. So sometimes people will decide to enter into mutual no contact orders because they aren't prepared to take a matter to a hearing, or there can be a variety of reasons why people might agree to that. But generally, with a mutual no contact order, there's no police enforcement of that. If the order was breached, then you'd have to make another court application. Sometimes people will enter into restraining orders. Those generally do have police enforcement, whether they're mutual restraining orders or one-way restraining orders. And again, there can be a variety of reasons to enter into those types of arrangements. And it's one of the reasons why it's a good idea to get duty counsel assigned.
Perfect. I see we just have about a minute left here. So I know we had some questions left over. So our apologies for not being able to get to all the questions that were asked today. Again, we just want to say a big thank you to Julia, Jessica, and Jackson for taking time out of their busy schedules to be able to share their expertise with us all. You'll notice in chat, I did drop a link to that survey that is anonymous. It should take 1 or 2 minutes. We're just looking for feedback about today's session, what other topics everyone's interested in attending. And then I'm also just on the screen going to show that, as you might have seen in my intro and behind me, so Legal Aid is celebrating its 50th anniversary this year, and we do have a special commemorative website that you're able to go to. It kind of gives information about where Legal Aid started, kind of the steps along the way, and all the work we're doing to improve access to justice to Albertans. So if you have an opportunity, we invite you to take a look at our website through our 50th page. I'll also drop a link in chat here to the website. Perfect. And then as a reminder, so we will send a copy of the PowerPoint that was shared today. We'll also have a link to the recording of the session that will probably go, I would assume, probably early next week. Everyone will receive that. And if you have any questions about today's session and want to provide any other feedback outside the survey, you can always send us an email to communications@legalaid.ab.ca. So I just dropped in the chat here. And again, please use the survey, but we also welcome any other feedback that folks have about your experience today. And again, thanks everyone for taking the time and